Good afternoon, everyone. My name is Jose Knight, or my friends know me as J Knight. I am the chair of the ADR section of MSBA's ADR section. In combination with MCDR, we will present to you how to be heard in ADR, verbal and nonverbal gestures. I'm proud of what the section and MCDR have done together with this. I hope you enjoy it. I'll turn it now over to Katie Huff, who will introduce everyone who will be involved in it. Thank you. I hope you enjoy it and have a great time.
Thank you, Jay. I am the treasurer for the ADR Section Council, and I am happy to help bring this program to you all today. Thank you all for coming. We are happy to have these lunchtime chats, and I hope we're able to continue having them over the next couple months. And these have been made possible by our very generous speakers that we have here today. Thank you all. And the ones we've had in the past, and also thanks to Angela with the MSBA. She has been making these all possible. She is the person running this all behind the scenes, helping you all register. So thank you, Angela. And also, we are lucky today to be presenting jointly with MCDR, which is the Maryland Council on Dispute Resolution. And our speakers we have here today are from both MSBA, from MCDR, and some are members of both. So we are very lucky to have that. Before we let you all meet our speakers today, though, we are going to do some poll questions so that we can meet you. We want to know who we have here in the room and let you all get to know each other in the very limited virtual world we have here today, but we want to see who's here. So our first poll question is, whether you're an attorney, mental health professional, mediator, or some combination of the both. And you may be able to check more than one if you fit more than one of those categories, which I know some of you do. So we'll give you a couple seconds to answer that. We have lots of responses coming in. This is awesome. So I'm going to show you all the results. So it looks like we have lots of mediators, lots of attorneys, a fair number of combinations, and some mental health professionals. And so we're going to move on to our second question. Angela, if you could put up our second question, which is, what areas of the law do you practice in? So that we can get a sense of who we have here. Okay, and it looks like we have a good mix of family law attorneys, those who do not do family law and do other work, including civil work. So we are going to move on to our third question, which is where you all typically mediate, whether you are court order mediators in the circuit or district court, or whether you mediate privately. And I know some of you, a lot of you do both. Okay, it looks like we have a lot of private mediators, but also a fair number of circuit court mediators and some district court mediators, and a mix as well. So thank you, Angela, for putting those polling questions up for us. And I am now going to introduce you to our moderator today, which is Cece Pace. I know a lot of you know her already. She has been so helpful in coming to these presentations and talking to you all. And Cece comes with a wealth of experience. She runs the Mediation Center and has been doing mediation since 2000, and she does those in all areas of the law. And she's also been providing mediation training since 2007, Some of you may have taken her courses. I know I have. And she does those trainings in the 40-hour basic civil, child access, divorce, financial, guardianship, and child in need of assistance mediation trainings. She is a member of the MSBA ADR section, and she was a prior chair of the MSBA ADR section council and treasurer for a long time. And she's also a member of the board for MCDR, and she was instrumental in getting this particular presentation to get us to team up between MSBA and MCDR to be able to bring this to you all. So I am going to hand it over to you, CC, to introduce the next of our speakers.
Well, thank you very much, Katie. Welcome, everybody. I do see a lot of familiar names and faces here, and I'm really pleased. Kimberly and I were the ones that sort of said, let's sit down, and try and do a program between the two groups. And that is kind of how this began. And we're hoping that you all will, towards the end, give us some ideas about other coffee chats that you might want to hear as a combined program. I think it brings a lot of great professionals together with a lot of different skill sets, and we can learn from each other as well as from the presenters. Today, the focus is going to be on how to be heard, meaning in multiple ways. First, it could be being heard as a mediator and having the participants hear what you're saying, but also to have to know that you're hearing what the participants are trying to say. And that we have three different perspectives here today. We have Judge Dennis Sweeney, we have John Greer, and we have Dr. Kimberly Cuthrell, who will be presenting their perspectives on this. And I'm going to start with Judge Sweeney and introduce him specifically. He is a senior judge who is now retired and is a mediator and an arbitrator with JAMS, which is the National Arbitration and Mediation Service. And he works from the JAMS Washington, DC office. He is a mediator with the Appellate Mediation Program at the Court of Special Appeals that Jay is in charge of. And I think that it's also important to know that prior to retiring, he was a full-time a full-time circuit court judge for the state of Maryland in Howard County. And that's how I came to know Judge Sweeney. He also turned out to be a neighbor and saw my husband and I attempting to stay in shape on occasion as we ran by. He is one of the first judges appointed to the Maryland Business and Technology Case Management Program. And he is also appears as a recalled judge and hears civil and criminal cases in various circuit courts in Central Maryland and the Eastern Shore. He is also a settlement judge in Anne Arundel and in Howard County, and perhaps others that he will tell us when he joins us. Before his appointment to the bench in 1991, Judge Sweeney was a Deputy Attorney General for the state of Maryland and also serves as the Chief of the Civil Division and Chief General Counsel in the Maryland Attorney General's Office. He has also served on the Judicial Ethics Committee of the Maryland Judiciary and as a Special Master for the U.S. District Court. Judge Sweeney earned his JD degree from the beloved Georgetown University Law Center, whose basketball team is now coached by Patrick Ewing. Sorry, I just had to throw that in. And in 1971, and his BA he received from Loyola College in Baltimore in 1967. So having said all that, I'm going to turn this over to Judge Sweeney.
Myself here. All right. Thank you, Cece. And thank you for inviting me. And this looks like a very distinguished group of mediators. Some of the names I recognize, and I note that there's several of my ex-colleagues who are part of the group here. I think I see Nate Braverman and Nancy Sugar and Michael Pearson and Warren Krug. And I'm somewhat intimidated to be saying things here because those folks have equally wonderful experience, and as well as many of the other folks here. But I'm going to do my best. As CC noted, I do have done mediations in various settings. One of which is JAMS, which is a private mediation service, and there, those mediations, I think, are more formally set up in the sense that they are, the clients are paying for the mediation service, and it can be much more extensive than some of the other mediation settings that we find ourselves in. I've also do the Court of Special Appeals mediations, which have the difference in that they are co-mediated with some wonderful folks in Jay's office that I have, I think, co-mediated with every one of them, and they're just all excellent. And I also do settlement conferences, which is another step in the mediation process, perhaps a more informal setting. And I do that in the circuit courts. So I have various different settings that I do mediations in, but there's a lot of similarities between them, and there's some big differences. One of the things I wanted to talk about was, to the extent possible, I find that in trying to communicate with people and to try to see if folks understand what the mediator is doing, and to kind of figure out what the relationships are here, I always find it very helpful, if that opportunity is available, to talk to the attorneys in advance of the actual mediation session. Now, that's not always able to be done, but where it can be done, I find it to be extremely helpful. Because one of the things I think you're trying to figure out in a mediation session is not so much that, obviously, the dynamic between the parties in the mediation and the conflicts that arise there, but also if you're talking, I think a lot of times the most interesting dynamic is that between the lawyer and the client, and trying to figure out kind of what's going on there. Are the lawyer and the client 100% on board? Are they have issues? What's the attorney's perspective? Obviously, what the client's perspective is. So what I will try to do is, I will try, if the circumstances permit it, to talk to, besides getting a mediation statement, and you're not really going to find this stuff out in the mediation statement generally, but I will call up the lawyer and I will just try to have as informal a chat with them as possible. And I will usually start it off by saying something like, just an open-ended questions like, tell me about your client. Just leave it at that. And sometimes, you know, the lawyer is a little taken aback by that, but I'll say, just tell me about your client. I don't mean the legal issues here, but tell me, what's your client like? And sometimes that can be very, very enlightening. And I will also ask them, how do you think this, how did this mediation come about? Who's the driving force in it? What's your, were you the initiator? Were you not the initiator? Was your client the initiator? How did this come about? And I think that can really disclose a lot that maybe they didn't want to put in the mediation statement, but that can be very enlightening. I will always ask, how are you getting along with the other counsel? You know, are things good with you guys, or are they not? You know, and a lot of times I'll get some really candid discussion there. And of course, I mean, obviously this, when I'm talking to them, they understand, and I make it clear to them, this is just the lawyer and I talking, and it's not going to go anywhere, but I find it to be very useful. Um, and that I will always ask them, what are there things I should avoid in dealing with your client? Are there subjects I shouldn't talk about? Or should I emphasize some things and not others? Is your client going to be very sensitive about certain things? Let me know. And to the extent I can find this out, sometimes this can be a little delicate question here. I'd like to know how the lawyers are being paid, and not only how they are being paid, but are they being paid? And a lot of times that doesn't come out. That's kind of a rude question, I think, to ask lawyers, but it usually comes out in the wash as we're talking about it. And I may ask the question: Can your client afford this case? Can your client afford to go ahead? Which kind of backs into the attorney compensation part of it, because I think everybody's been in mediations where you're trying to figure out, does the lawyer really want to settle this thing? Does the lawyer not want to settle this thing? Does the client really want to settle the thing? Sometimes you get a case where the lawyer seems to be more invested in continuing the case than the client is. And so I really try to make that a part of a mediation I can do where I have the time and ability in advance of the mediation. Now, in settlement conference in court, you really can't do that very well. I mean, I guess you could do it, but it's kind of hard because of the way things are scheduled, and you don't really get the contact information in time, et cetera. But a lot of times, I always try to get to, if it's an in-person mediation, I always try to get to the mediation before anybody else gets there. And I will take, if one of the lawyers gets there early, and I haven't done this, what I just described about, I will take the lawyer, outside the conference room, and I would just say, tell me about what this, I read your mediation statement, I read what you submitted in your pretrial statement, but just tell me kind of what really is going on here. And I find that to be very helpful. And I know some mediators don't, some of our James mediators don't do that at all. They think it's, much better to just kind of go in and to the mediation session without that background. But I have found it to be one of the most effective things to do. Another thing is, and we're talking about reading clients, reading the parties and trying to figure it out. I generally do not demand that there be opening statements, but sometimes the lawyers want to do opening statements, or sometimes the situation just kind of calls for there to be opening statements in a mediation. As I think everybody knows, they can be things where you get off on potentially on a wrong foot, but maybe that foot isn't so wrong because everybody's kind of getting out their feelings at this time. But if people do opening statements, I really don't look at the person who's doing the opening statement. I'm looking at the parties. I really am interested. I think that's the most beneficial thing is not so much what the people are saying in the opening statements, but how are the parties reacting to it? If they're just kind of blasé, but sometimes you can just see they're getting angrier and angrier, or sometimes they're surprised. One of the lawyers says something, and you can tell that they'd never heard about that particular thing before, because maybe their lawyer hadn't told them about that. A witness that they've never heard about who's going to submarine their case. And so I really focus on looking at the clients to see how they're taking this and see how well they were prepared for this mediation by their attorneys. One of the things, and I'm a convert on this, when I started doing the Court of Special Appeals case, and I don't know how many of you all do co-mediation with other folks, but when I first started doing this as a Court of Special Appeals thing, and I had been doing mediations by myself since '07. When we started doing the Court of Special Appeals things, I was really skeptical about how that would work and whether that was a good thing. It seemed to me like it was just going to kind of mess things up and get conflicting things going on between the mediators who aren't necessarily on the same wavelength. But I've been converted that it's a good thing. And particularly the way the Court of Special Appeals does that. They pair up a retired judge, senior judge like myself, with one of their attorney mediators who are on staff there, and that has worked out nicely. And some of the aspects I think that have actually helped that to work out is you have a judge and a non-judge, a lawyer, a judge and a lawyer doing it. So the judge is coming at it from one kind of angle, the lawyer is coming at it from another angle. Almost by definition, all of us senior judges are old folks, and most of the mediators, and I would say all the mediators, by my standards, are very young, and that just having that dynamic, I think, is useful. And it's just not this kind of grumpy old judge there who's saying things, but there's also this younger, more vibrant person saying things too. And I think that dynamic is, to my surprise, has been very helpful. I also think, and I'd be interested what other folks' thoughts are about this, is I think it's really nice in a family law case if you can co-mediate and you can have a male and a female doing the co-mediation. I think that's very helpful. And I know that I have actually been asked to be a co-mediator, not only with the Court of Special Appeals, but in a few times I've done a private mediation where they wanted a male to be part of it, basically so I could, put my arm around the guy and say, put an arm around his shoulder and say, "Hey, buddy, come on, going to have to get over, we're going to have to settle this thing." And so that is, and with co-mediators too, you can have different styles, and the styles can work with each other of more formality, less formality. You can have one person, and so I think it's it's obviously not available in a whole lot of situations, but to the extent you can do it, and I think it really helps too in reading the parties and reading the lawyers, is to be able to parse this out by talking to somebody else. Some of the most useful discussions are the ones I have with the co-mediators in between caucus sessions, where I will say what I'm thinking, and they'll say, "Yeah, you're right," or they'll say, "No, that's not right. No."
If I may, Your
Yeah.
Honor, the other thing in family, the first 7 years that I worked as a mediator, I co-mediated with a clinical psychologist. So it was a female lawyer and a male psychologist, and the dynamic in family was excellent.
Yeah, I could see that being a very good combination too. Also, one of the other things I try to do is, and sometimes this can seem like it's kind of a off the point or whatever, is when we get into a mediation session, when we're dealing with the parties themselves, particularly in caucus, I will talk to the party about something totally unrelated to the case. I will ask them questions, either doing with their occupation or dealing with their kids or their grandkids, or a restaurant that I know is near their place or something like that, something that has nothing to do with the case. And one of the things I do, and then I'll carry on that conversation and I'll go back and forth. I had one one case recently where in a mediation session, the lady who was the plaintiff in a tort action, she I knew she had teenage kids, and I knew she was here in Howard County, so I asked her what high school her kids went to, and Cece will appreciate this. It happened to be River Hill, okay? And they played sports, and as Cece knows, because Cece's daughters and my daughters played in the same team, not the same time, but the same soccer team. River Hill was like our arch enemy, and so I'm throwing shade on River Hill. She's throwing shade on Centennial, and we're having the best time. It has nothing to do with this case, nothing to do at all with it. But we got on a good setting, and also you get to see, by this totally unrelated thing, you get to see that person outside of the issues that brought us here, and they're more maybe hopefully they're more relaxed, they're friendlier and everything like that before we go back and start talking about the very serious thing that brings us to their case. So that's that I think that's useful. I mean, some people could say we're just wasting time and let's get to the issues. Sometimes the lawyers think that, but I find that to be useful. The one of the things that you want to be careful about, I think I'm kind of noted for it, is do you bring any humor into the mediation? Do you? That can be very dangerous because a lot of people's humor isn't the same. One thing that's funny to an old guy like me, 75-year-old guy like me, ain't necessarily going to be funny to anybody else. But I think it's another way to relax folks, to tell them, I will tell them, I have some story which are self-deprecating. I am the butt of all these things that I say, but I'll do it and I'll see, am I getting any reaction? Is the person, and what if the person is starting to relax and feel like, they may groan at my joke or my attempted humor, but that's actually good, I think. We're getting into a very relaxed situation. There's certain advantages to being a judge. I think there's certain disadvantages to being a judge. I think one of the biggest advantages is I do think a whole lot of folks feel like they need to say something to somebody in authority. And by definition, you're a judge, so they feel like when they're talking to you, we do all the caveats about, I'm not deciding anything here, I'm not making a ruling or whatever, but they feel like they've had their chance to really talk to somebody who could understand what this all means to them. And I think that's a very good thing for a lot of folks. And you can obviously get that in other ways with letting folks tell their stories, but it helps to be a judge. And when we always start out the mediations, we always, I think doing the Court of Special Appeals mediations, my co-mediators are always anxious, and I think rightly so, to get folks to use first names, so everybody's, Jim and John and Katie and whatever, so that we're all on a first name basis. I always make sure that I'm still called judge, because I think that helps the whole mediation thing. And I always tell folks, this is one of my humorous stories here, I always tell them that when I became a grandfather for the first time, my daughter said to me, she said, "What do you want to be called? Do you want to be called Grandpa, Paw, She gave me a list of about 6 things, all of which I thought were appalling. And I said, how about Judge? And so it stuck. and all my grandkids call me Judge. And I told my daughter, I said, when they get to be about 5 years old, I'm going to say, call me Your Honor. But for right now, it'll be Judge, And so I think being a judge is a useful thing in a mediation. But there's some downsides to it, which is, I think judges, tend to be, sometimes when I talk to judges who are getting into mediation, I say you have to get out of your judge mode of being judicious, because you're not helping anybody by being judicious. You got to get into it. You got to, sometimes I think judges think, well, I'll listen to both sides and then I'll say, this is the way it should go. And because that's what I've done for, the last 15, 16 years. But I think you really have to get into it with the people. You got to listen to stuff that's totally irrelevant. You got to, the whole thing. That's one of the things I actually like about doing the remote things is you get to get an idea of where people are coming from, in terms of, you get to see as much as we're seeing here right now. And I will often ask folks about something that's in the room, and I will, if they have, we were doing one of these, I think Court of Special Appeals one not too long ago, where it was a grandmother and she had her grandson who kept, calling out and knocking on the door and things like that. And finally, I just said, hey, bring him in. Put him up on your lap, and let's. And he was the cutest little kid, and we had a nice little chat about that. And nothing to do with the case, but I think it's helpful in creating trust back and forth. I don't know if people are aware of this. There is a website, or I guess it's a Twitter site, really. It's called Room Rater, R-A-T-E-R, Room Rater. Have you all heard about this? Where these folks, they rate the background for Zoom backgrounds. This is like for celebrities and for news people and whatever. And they give them scores that could go all the way from 0 to 10, and they talk about the different things that make a good Zoom background. By the way, John, your background will get close to 0. I'm just telling you that, okay? Because they say that looks like a hostage video site. Okay.
I do think that Victor's looks very nice. He's out on a beach.
Where, yeah, right now, but you see, you'd lose points because it dissolves around the edge of your head, when you move.
True.
And so,
True.
But it's always good to have a plant, a piece of artwork, and whatever. But the point of this is, in doing the remote mediations, you get to see a little bit of that and kind of get something you can use as a discussion thing. I had one the other day where the lady there's a dollhouse, a lovely dollhouse behind her, which led to a discussion. Now, this may all sound like I don't talk about the case at all, but I think that these things, once you get the confidence of folks, I think it can be very.
So
yeah, go ahead. I'm probably over time.
That's all right. If I could just kind of summarize a little bit of what you were saying, is I think I'm hearing that your process really makes people buy into the mediation, feel comfortable with you, and therefore feel heard, by making them feel heard at the very beginning, by talking about who they are, not just what the case is about.
Exactly.
I think that is very helpful. I also wanted to point out that being known as judge is very useful, I would assume, when you're doling out timeouts for the grandchildren. So,
well, that doesn't work as well as it does in court, but
Oh, there you go. And also, I think everyone that's attending it can appreciate that oftentimes retired judges are selected for the very reason that they want to be heard by someone of that background. And so oftentimes just being selected because you're a retired judge is already, how people want you to hear them. And that can be very helpful as well. I did see something in the chats about building rapport, and that rapport is the lubricant. And I think that is really a good way of putting what Judge Sweeney is talking about. Really developing that so people feel comfortable when you start asking questions, answering them, and letting you hear what they have to say. Does that sound like a good sum up there, Judge Sweeney?
Yeah, that sounds good. And we could have done this whole thing in 2 minutes and see.
Oh, no. The stories are the most important part of all of this. So, and you have a ton, I'm sure, but it is still go Eagles, not Hawks for Howard County. So.
Right, exactly. Right. Yeah.
All right. Well, the next one up to speak on this subject would be John Greer. And John and I actually are presenting, I've pulled John into my 40-hour basic training because my primary focus is family law mostly, although I do mediation in all areas. I'm known for my family law mediation. And John brings that other element, the civil non-family, to the table. And John does have extensive skills and experience in the field of all three fields of mediation, arbitration, and negotiation. John is a member of the National Academy of Distinguished Neutrals, which he nominated me for, and I am now a member of that distinguished body. Thank you, John. He is certified as a mediator by the Maryland Council for Dispute Resolution. And I wanted to clarify that when you take a course, you get a certificate, but you're not certified. The MCDR does have a program by which you can be observed, coached, and then you would receive a certification from them that they have followed a process that shows you are of that level. He is on the roster for the mediators for the Better Business Bureau and the District of Columbia Court of Appeals, as well as 10 circuit courts in Maryland. I'm sure that's much easier now that we're doing it by Zoom. I can't imagine driving to all those areas. As an arbitrator, he is an arbitrator for the Better Business Bureau, as well as the Financial Industry Regulatory Authority, handling disputes in the securities industry. That's not something I would ever go anywhere near, John. Teaching, he is an adjunct faculty member at the University of Maryland Carey School of Law, and he teaches negotiation and dispute resolution. He is admitted to the Maryland and District of Columbia bars and is retired from the practice of law. He owns and operates his own dispute resolution practice known as Patuxent Mediation Services, LLC, and you can find him at patuxentmediation.com. So having said that, I'm going to go ahead and turn this over to John.
Thank you, CC. I really appreciate it. And thank you, Judge Sweeney. You're a tough act to follow, but I'll do my best. And like you, I see many longstanding friends and see a lot of new friends. I hope to make acquaintances. So CC asked me to talk today on the topic of how to get the parties to listen to the mediator. So we all know the techniques of empathetic listening, asking open-ended questions, reflecting back. So I'm not really going to delve into those very much, but I want to go deeper by exploring some structural reasons why parties don't listen to the mediator, and then offer some practical tips for dealing with these kinds of issues. I'm going to speak today based on a new book by John Landy called Litigation Interest and Risk Assessment, Help Your Clients Make Good Litigation Decisions. The book is available from the ABA. I'm doing this with permission from Professor Landy and the ABA, and I'm going to draw some insights from the book and apply them to lessons that I've learned from my experience mediating civil non-domestic cases in the circuit courts. So this happens to me all the time, and I'm wondering if it happens to you. So I'm in caucus with the plaintiff and his attorney, and I ask if they have an initial demand. The attorney says $1 million. And I say, how did you arrive at that number? She doesn't listen to me, and she says, that's my number. So being a good mediator, I ask how she thinks the other party will react. And she says, just take that number over. So I go over to the insurance adjuster and his attorney and tell them the plaintiff's asking for $1 million. The attorney says, are they crazy? We're out of here unless they get real. So again, being a good mediator, I ask, well, what would they consider realistic? They don't listen to me. They tell me to take over an offer of $5,000. Okay. So now the mediation turns into a long day of shell diplomacy. Each party makes tiny moves. Professor Landy notes that at each step, the plaintiff experiences significant pain, and it's caused by a sense of loss. And it's been called a grieving process, and I've really experienced this in my circuit court mediations. It's a grieving process for the plaintiff as the plaintiff struggles to cope with unmet expectations and being asked to settle for less than what he thinks he wants. Okay, so one cause of this could be bad communications between the lawyers and their clients, and this builds on what Judge Sweeney talked about. Quite often, and you have to be aware of this, the attorney and the client are not communicating. They're not listening to each other. This can lead them to make bad decisions about settling, and it also affects whether they're going to listen to the mediator. And you can be aware of some of this and recognize that this is happening because there's some hallmarks. Hallmarks can include making extreme demands, making few concessions, and being unwilling to share information, even with the mediator. So what are the sources of these bad communications between the clients and their lawyers? Professor Landy points out that lawyers are oriented to the law and trial outcomes. I do mostly distributive mediations, and so what this means is that the lawyers are focused on monetary outcomes, and they develop their BATNAs based on the expected monetary result at trial. At the same time, clients, according to Professor Landy, may have interests beyond a monetary outcome. He cites studies showing that clients frequently complain about their lawyers and because they have a lack of empathy and understanding, they have a lack of respect for the client, and a lack of communication with the client. Clients are often frustrated that their attorneys don't listen to their non-monetary interests. These are intangible interests, and they can include a lot of things like a desire to be heard, that we've just talked about, the ability to exercise control over the process, avoiding stress, participating in what they consider to be a fair process, maintaining important relationships, and protecting their reputations. A big intangible that I see a lot in my work is closure. And that is, clients quite often really want to get the case done and over with so they can get back to what they consider important in their personal and business lives. So I really want to stress that. So the result of all of this is that lawyers and their clients get locked into what one researcher calls parallel worlds of understanding. Opportunities are going to be missed for settling the case, despite the best efforts of the mediator. So on the lawyer side, Professor Landy calls them locked into a prison of fear, his words. They're afraid to be candid with their clients, and they give overly optimistic assessments of trial outcomes because they're afraid the client won't hire them. And on top of that, we all know that trial outcomes are very uncertain, and so it's quite often difficult for attorneys to communicate effectively with clients about possible trial outcomes. On the other side, Professor Landy says clients are locked into what he calls a conspiracy of optimism because they want the lawyer to take the case. So they put the best face on the case, which can be unrealistic, and might even be a misrepresentation. So if the clients and the lawyers are not listening to each other, how can the mediator get them to listen to the mediator? So the best way that I have found to get the parties to listen to the mediator is to elicit their interests. And so the emphasis here is on elicitation. Studies in Maryland, and some of you are probably quite familiar with this, have shown that elicitation is the most effective technique that mediators can use. There was a study by the Maryland Judiciary called the Statewide Evaluation of ADR. They examined mediator elicitation strategies, which included asking participants to suggest solutions, summarizing the solutions that are offered, and then asking the participants how those solutions might work for them. The study shows that when mediators use the eliciting strategy, the parties felt they listened and understood each other better, and they jointly controlled the process. And the parties felt that mediators who used this eliciting strategy did not control the outcome, did not pressure them into solutions, and did not prevent issues from coming out. So the goal of eliciting interests, according to Professor Landy, is to help the parties make informed decisions about their bottom lines. If the lawyers and the clients are not listening to each other, it's very likely that their assessments of their trial risk may be skewed. So the mediator's job, and this is what I do in my work, is to help them make better risk assessments. And mediator can do that by taking into account their full range of concerns. For example, a party might be willing to pay more to settle a case if he can reduce the harm to his reputation, which is a non-monetary intangible interest. So Professor Landy recommends that in addition to talking to clients about expected trial outcomes, mediators should elicit party expectations about tangible costs as well as intangible costs and interests. So what are these? Tangible costs are things like attorney's fees, deposition costs, expert witness fees. Intangible interests can include avoiding stress, hassle of going on with trial if the case doesn't settle in mediation, and the real effects on physical and emotional health of the parties. And again, I really want to emphasize the importance to the parties of getting closure. So kind of my bottom line is that the parties are more likely to listen to the mediator who elicits their interests, because when you get the full range of not only trial outcomes, but tangible costs and intangible interests, all three of those areas can be addressed in a single framework. And I think that helps establish the communication between the parties and the mediator. So when should the mediator conduct this? I fully agree with Judge Sweeney. I make this my practice. I do this as early in the pre-mediation discussions with each party separately as I can. And then later on during the mediation in caucus, I keep checking back in to see if any expectations have been changed during the mediation. All of this builds trust, and the more trust the parties have in the mediator, the more likely they will be to listen to the mediator. So let me kind of break these down a little bit. And like Judge Sweeney, I make it my practice to elicit interests early in separate and confidential phone calls with each attorney. I do this after I've read their mediation statements and well before the day of mediation. So when I do this, when I make this call to the attorney, which is all confidential, I have a good sense of the dollar amounts that they want, and because I ask about that in the mediation statement template that I use. But then I ask if the attorney has a sense of whether the client has any non-monetary goals. And Quite often the attorneys are candid, which is appreciated because I know going into the mediation what I'm dealing with. And if they're not candid, that tells me something as well. That tells me they're hardline, and it kind of lets me know what I'm going to be facing in the mediation. Okay, so that's before the mediation before the day of mediation. Now, on the day of mediation, I meet separately with the attorney and client, and here's where I usually get to see the client for the first time. So this is where I start eliciting interest directly from the client. And I focus on intangible interests because they can help guide the discussions during the mediation. So one thing I'd like to do is share a few questions. These are taken from Professor Landy's book, and let me know if this is not coming through. So this is, as I say, on the day of mediation, this is the first chance I have to talk to the client directly. It's with the attorney. It's separate. This is not in joint session. And I'll ask these types of questions. What do you hope to get out of today's mediation? And that, the answer to that is pretty important in terms of, where I think the client thinks things can go. I'll ask how the litigation has affected them, and how it fits in with their other goals. And here's an example. If they tell me that reputation and relationships are really important, that's an important non-monetary interest that is really important for me to know as things get on down into the mediation, because they might be willing to accept some settlements that don't damage their relationships or reputation. We talk about how long it might take if we don't settle. What might they be looking at in terms of time? And then, I point out some other things like the hassle factor, the effect on their health or their relationships if this litigation proceeds beyond the mediation. So those are some questions that I ask up front before the actual mediation starts. Okay. All right. Okay. Now, so we're in mediation, and we've gone back and forth, and the parties are starting to get kind of tired. We've been making some progress closing the gap, but it's starting to slow. Now, this is the point where trust in the mediator really becomes important. So I try to get a sense from reading the room about when it's appropriate to go deeper than just eliciting interest and start to have the parties examine their risk assessment. So I may change the focus of my elicitation questions. I'm still eliciting, but the focus may change from information gathering to what's been called reality testing. You've probably heard that before. So I'll ask a series of questions that's designed to get the parties to think more about their tangible and intangible costs if we don't settle and this thing goes on a trial. Okay. So again, emphasis on elicitation, not directing, right? I think directing, and we all agree, is a violation of party self-determination. So I'm going to be really careful to ask these questions in a neutral manner, because I don't want to give an appearance of bias. So I'm going to share the next slides. I have 2 more slides. Let's see here. That is the first one. Now, can I get the next one? Sorry, folks. That's not working. Let me try again. Okay. All right. I'm sorry. Let me go back. It's working now. All right.
John, while you're clicking around, we have a question in the chat about whether we could get the list of questions that you had just had up on the screen. Can we share your slides with the participants today?
You may. They're subject to copyright restriction from the ABA, which is stated on the slide itself. So subject to that, yes. And we are recording this too. So, okay. Okay. So these are some questions to the client, and I'm trying to elicit tangible costs, like things like how much have you already incurred in attorney's fees, how much more do you think you're going to spend in attorney's fees, things like depositions. If they haven't, sometimes they go to mediation early. They want to save the cost of depositions, but you know, if we don't settle, they'll have to go through that. Expert witnesses and that sort of thing. So I try to get them to focus on all the expenses that are going to come if they go on into trial, and then to ask them questions about how these might fit into their overall plans, and if you know, if you don't have to spend this money, what else would you do with it? Let's see if I can get to the next slide. And that's not happening. All right, let me try again. Sorry, this seems to be not working. All right, here we go.
John, while you're doing that, we're getting a little close to the end of the time for you.
All right, got it. Somehow it's not really working here.
Technology is wonderful when it works easily.
Correct. This is not working, of course. Okay, tell you what. Let me okay, I see some questions coming. I'm happy to address these questions. Let me see if I can get this slide up here. This is not really working. All right, that's the tangible costs. Oh, okay, this is really, I'm sorry. Yeah, let me try one more time here, and this is really not working. Okay. I can see it on my slide, but it's just not working. All right. Well, these are things. These are let's go back. I'll just keep going. Sorry. They can be shared. Angela can make these slides available. But these are things that you can ask to elicit interest. Things like, you know, are there non-monetary questions or issues about your reputation, issues about how it's affecting your health, your family relationships, and try to get them to think about intangible factors, okay? So let me wrap up, Cece. You have to be careful when you're doing this, and you have to make a judgment about how evaluative you want to be. I know that that's a big issue for a lot of mediators. I try not to be evaluative in the sense that I don't give opinions on trial outcomes. I don't give opinions on where people ought to settle. I don't give opinions on what their next proposal should be. Rather, I will ask them a series of questions that try to get them to make their own assessments. I will ask them if they, you know, what are some issues that are likely to come out at trial, and how do you think they're going to go at trial if we don't settle today? I will point out some things that the other party has, other points the party has made, and ask how they plan to handle that at trial. And these types of questions help them focus on their own risk assessment. Sometimes the parties will ask me, well, what should I do? I sidestep those kinds of questions, and I'll say, I will ask them if it's late in the day and things are kind of stuck. I will say things like, well, would you like my mediator sense? Okay, so it's an invitation. Again, I'm not directing them, and I'm not telling them. I will ask them if they want my mediator sense. If they say yes, what I'll usually say is, well, my sense is, and this is usually true, if we've narrowed the gap over the rest of the day, I'll say my sense is that this mediation can settle. I think there is a number out there that'll settle this case. Let's go find that number. Let's keep going. And that usually builds some momentum, and the case keeps moving along. The problem with if you give your own assessment of where this case might come out or what the party ought to move, next, and it goes south, guess who gets the blame, right? So I'm very careful about party self-determination, but I will ask a lot of questions to get them to make their own assessments, particularly, and I get very specific. I'll say, all right, what about negligence in this case? What about contributory negligence? How are you going to handle that if it's raised? And that sort of, so I'll get very specific, but it's still their answer. So with that, I'll just wrap up, Cece.
Well, thank you, John. I appreciate it. I do want to note that Jeff Truman, who John and I have presented programs with before, kind of put something in the chat that I think would be helpful for everyone to read through from his perspective. But one of the things that I wanted to highlight on that is something that I think John was saying, not quite as directly, but this is what I think he meant, is generating movement is what matters most in Jeff's opinion. And I always tell people, as long as we're talking, there's a possibility. It's when we stop talking that we're no longer able. But then I also follow it up with, but we also have to listen. And what I'm hearing John say, is that, there are ways of asking these questions that really does elicit their perspective, their opinion, versus having them look at you and say, what do you think? Which becomes a more analytical or evaluative process and does move a little farther away from self-determination. The parties who really feel that they're being heard and listened to are more inclined to listen, is what most studies show. But having said that, I would like to introduce our next speaker, who is going to kind of speak to that concept, Dr. Kimberly Cuthrell. And did I pronounce that correctly?
Correctly, okay.
Well, with a name like Pays, I always have to tell people, no, it's Pays. But to introduce her, Kimberly is a member of the Maryland Council of Dispute Resolution, as was noted before. And she co-chairs the Maryland Council, the MCDR Programs Committee, which I'm part of. And I am the bar bench liaison, apparently, since I'm also on other boards. I'm learning as I slide towards closer to retirement, that the word no can be very helpful. But at this point, I haven't learned it. And it doesn't sound like Kimberly has either. She's the founder and managing attorney of the Cuthrell Law Firm, LLC, and a mediator in Maryland. She has a doctoral level behavioral health therapist, or she is a doctoral level behavioral health therapist. She is the owner of Serenity Counseling and Resource Center, Inc. in North Carolina, where individuals and families diagnosed with mental health and substance abuse disorders and intellectual development and disabilities can receive behavioral health services. She combines her knowledge as an attorney, therapist, and mediator to promote trauma-informed legal advocacy and mediation. She has experience conducting court-ordered, non-court-ordered specialized clinical evaluations and offers mediation designed for individuals with and without behavioral health diagnoses. As a lifelong learner, we already note that she has a PhD and she's an attorney and she is a therapist. She has been accepted into medical school where she plans to combine her experience as an attorney, therapist, and mediator with medical knowledge to become a forensic psychiatrist with the aspiration of expanding existing trauma-informed approaches of legal, clinical, and mediation practices. Having said all that, I think we are going to be learning a great deal by listening to her today. And if not, we'll invite her back after she's done with medical school and she'll just have to tell us more.
Oh, greetings. Thank you so much, CC. It is such a pleasure to present today and to follow up from Judge Sweeney and John, so to have the honor of doing so. Today, we are going to discuss some wonderful things, strategies to get the parties to listen to each other, verbal and nonverbal cues and gestures, as well as mediators. And these strategies are powerful communication tools, especially with or without for an individual with behavioral health conditions. It influences our way of thinking and our interaction with others, especially with parties. And it has a significant impact on parties and mediation. And I have seen that from being a mediator as well as an attorney and a therapist to see how these things does intertwine. So good communication is one of the many keys and factors for a successful outcome in mediation. The parties must be heard. They must feel like the mediator is listening and also the one another with the parties. It is a powerful tool that helps mediators to connect with parties when you're looking at verbal and nonverbal clues. Now, there is no expectation for mediators to be behavioral health experts or have a significant understanding of behavioral health factors and conditions like mental health, our substance use, our intellectual and developmental disability. But it does help to create that momentum and the flow of communication when you are working with or without an individual who has a behavioral health circumstance. Yet having an understanding of how potential verbal and nonverbal cues and gestures can impact the mediation process, it helps to create that level of understanding and that rapport early on, especially when individuals who may have some type of trauma background. I am a strong advocate for trauma-informed legal advocacy as well as in mediation, because we hear about the things with verbal and nonverbal. When we key into the tone of voice of the parties, whether it's flat, whether it's slow, whether they're disinterested, loud, or hyperactive in speech, lethargic, or mumbling, that gives a clue as to the process, the mediation process. The facial expression, even though now with wearing masks, it does kind of cover up the true essence of what and how the person is perceiving the communication, the comments, because you can't see the entire face, which sometimes masks that true feeling, that true speech. So if a person is frowning, if they're smiling, if they look puzzled, it's in a sense difficult to really gauge if they are hearing or if they're just listening. And you want to keep that communication flow going. Whether their eye contact is very key for the mediator and the parties to take notice. If they're dazing off, if they are squinting, that gives some type of clue of some confusion or needing a little more clarification. The body movements, if they are shifting, if they're leaning, as if though there is disengagement, it could mean something else. And when we really talk about that in a minute about perception as trauma comes into play. The touch, when we were in person, a firm handshake says a lot versus a soft handshake, a level of uncertainty, a level of uneasiness, a level of uncomfortableness. It tells a lot about how the party or both are engaging or have their feeling as to how the mediation process is going. The space, is there a matter of invading the boundaries, being too close? That tells a lot. Or sitting far at distance. Well, of course, now with social distancing, we have to, but when we are engaged in the same room, look and see how the spacing is there. One key thing with verbal and nonverbal cues and gestures that many overlook, and that is perception. Perception of how the parties perceive the mediation is. And what is mediation? For many parties who may have a behavioral health, mental health background, when I say behavioral health, because that is the term that is used to encompass all mental health, substance use, intellectual, and behavioral health concepts. The perception of what mediation is needs to be explained clearly and upfront. As mediators, we know the process and we try to convey that to the parties, but making sure that they understand it, not from what they see on paper, but when we are engaging. Ask some specific questions, and which I'm going to go into those specific things as we move along. But perception is very key. The way the parties perceive the process, not the mediator, because the parties may be doing certain things as a way to cope. They may look off, and the mediator may assume that the person is disengaged, whereby that may be that party's way of coping. Because what we may perceive mediation as a standard and ordinary process, for one of the parties or both, it can be a potentially traumatic process. Whereas already that intensity of anxiety going into mediation, possibly a person with a traumatic past may feel an intense level of trauma, and dazing off may not necessarily mean disengaged, may not necessarily mean disinterest, maybe that person's way of not crying or not feeling the intensity level of that anxiety. And sometimes masking true feelings behind situations. A person may nod in agreement with the mediator just to get the process to move along, because that sudden question, how are you doing, may trigger. And so ways to deal with ordinary situation. That is something that mediators, I feel, needs to seriously look at, because you have to make sure that the individual, when they're engaging, is it an emotional balance? Are we asking key questions, in which I will go into further detail in a minute and I will remember, okay? And so building that relationship, that rapport early on, letting the parties retain control of the process, inquiring what is it that you are looking for in the mediation process. Not what I feel as the mediator, but what is it that you are specifically wanting out of it? Whether their decision may be realistic or unrealistic, allow them to be heard. And so that way you help guide it, but they must remain in control. And for a person with behavioral health aspects or trauma, that is one of the key things that impacts the fear of losing control, whether it's in a mediation process, whether it's in a court process, that concerning of being able to be heard and to be recognized, because that is very important. Whereas in mediation, sometimes we may perceive, and whether as in the scope of me being a lawyer or a mediator or a therapist, when a person misses appointments, when a person is tardy, when they avoid certain things, I have to check in with them to say, now, what is the real reason why? Well, I feel anxiety, or I don't feel comfortable with this setting, or I don't want to be in the presence of the other person. And so sometimes those nonverbal tendencies of missing appointments, tardiness, being irresponsible, not following through, may also mean something else. And we have to check in. So what I'm hearing you say is, so help me to understand what I'm listening to you, but it's not matching up. So they want to feel having an opinion matters and being heard. And also another perception is differences of viewpoints. Checking in with them. I hear you saying this, but let me get a little more clarification, and helping them to engage the thought process. And also communicating their concerns so that way they can be heard, but making sure they stay focused on the topic, because sometimes too many questions just tumbling at one speed can create that unbalance. And we also have to be sensitive to topics, to ask early on, is there something that I need to focus on? Is there something I shouldn't be focusing on? Is there a topic that you don't want me to touch on? Because that matters when it comes to whether a person has a behavioral health condition or not. Letting them be heard, having a voice to be able to say, well, I don't want you to mention too much of this, but it's okay. Well, how would you want me to phrase it? So they feel in control early on, gauge in the communication, having that fluid interaction is very important. Now, strategies to get the parties to listen to each other, as well as different tools a mediator can use to facilitate the fluency of the communication process. Now, there is no single solution for every aspect, and there is no expectation for mediators to say, I want to be an expert in behavioral health, but to know some contents, because sometimes the parties may not disclose it. And so, but there are some mindful concepts to consider. One is clear expectation of the process, making sure that they are aware. And it's not just about, I'm giving you the forms, read over it, sign it. Let me know if you have questions. Tailoring the intake process, the forms, to have special accommodations, not just for individuals who may need a accessible wheelchair and so forth, but inquiring about, are there conditions that I need to consider, whether it be behavioral health, and is there a certain approach that you want me to follow or to consider in the mediation process? The party's readiness for mediation, because sometimes they may not be ready at that specific time. Having that emotional balance. The parties must feel that they're being heard, and whatever is going on with them, they need to have that opportunity to communicate that. That flow of communication process and mediation process, that's what guides the entire interaction. Pay attention to inconsistency. Check in with the parties. Take a step back to summarize for clarification. And you want to say things, let me make sure everyone is hearing the same thing. Just in case if you see someone agreeing, but you see a frown, that everyone is in their listening mode to make sure that if it's anything that's hindering the flow, that it is addressed. And you want to make sure that this is what I'm hearing you say, but if this is not what you're saying, and so that both parties or the individuals are all equally listening and have that sense of control in the process. Maintain a consistency flow of communication. Try to match the words, what the person is saying, to the nonverbal that you may see unfolding before you, because that's going to give and guide, engage the process as well. So that way that you are clear and they're just not agreeing, because sometimes when individuals go through trauma or have some reluctance, they may just agree with the other party just to get it over with. And later on, have some type of emotional imbalance because they just want to get it over with. And the mediator or the individual that is overseeing the matter didn't check in, didn't notice it. And you would think that a person would have the onus to say, hey, I feel uncomfortable. But many people are not open to do so. But establishing that rapport early on, guiding the communication, allowing them to be in control, helps to try to create a more positive and conducive environment so an individual feels more engaged. Having that emotional awareness is another. When you see a person bow down with their head lowered, or they close their eyes, or they look over, or they start seeming like they're pulsating, they're breathing fast, check in. Do we need a break? Let me check in with you. And recognizing when caucus is important and when it's not. Sometimes caucus can be ineffective, especially when it's someone with a significant trauma aspect, because they may feel that something is being communicated and they may feel a sense of uneasiness that they're not aware of. But caucus can also be beneficial to be able to see sides, to be able to check in one-on-one with that person. Hey, how are you doing with this matter? And then also cultural differences. Just because you may see a group that may stare off and it may perceive that's disengaged, it may be a way in culture, it may be a way in emotionally balancing what they are used to as a coping mechanism. So recognizing the cultural perspectives is very important. And another key point is the management of stress and tension in the mediation process. When you notice things are unbalanced, because stress may compromise the flow of communication, the flow of the process. And so we want to accurately read the parties and read ourselves as mediators, checking in with ourselves to monitor reactions to comments, to balance the expressed words with reactions. The mediator may say something and they may see the person retreat. Another party may say something and the person may lean forward with great intensity. That's not meaning that that person's engaged. Is that person angry? Is that person feeling insulted? So we have to engage it. And it's not where it's a balance of I have to be a mediator and a therapist. Is that what you're saying? No, it's a matter of checking in, matching nonverbal with verbal cues to be clear that this is what you're hearing and not just listening. What you're hearing, is it matching up? But you want to balance your own instinct. Monitor the interaction between the parties. Do one seem to be overpowering the conversation, taking over? And the mediator is supposed to create that sense of balance. And having a fair balance of communication, exchange, and power. Determine whether what process is beneficial by allowing the parties to discuss the process and separating processes to be able to say it cannot be a step by step sometimes. You have to allow the parties to control it, but keeping it within the scope of mediation. And finally, make processes constructive and engaging to empower all parties to have that cautious thinking for ourselves. Is this working? Because we can't have a standard guideline at all times because it doesn't fit for every process. And determine the party's interest to make an informed decision. That is very key when we think about how and when nonverbal and verbal cues intertwine with one another. So that way we were hearing and we are summarizing and we are checking in. And it starts with the very first contact, asking on intake forms, asking on screening processes. What are your interests? Is there something I should consider? Are there special accommodations? Is there something I need to be aware of? How would I better engage the process to help encourage you to have that in control? Those are things, and you can also take it a step. Is there something related to behavioral health that I need to consider? Because sometimes it creates a more positive outcome for families, especially when there are family interactions. So in summarizing, with this aspect, strategies of getting the parties to listen to each other and mediators as well, verbal and nonverbal gestures, it is a powerful communication tools, but we must be able to balance it to make sure that all parties are being heard. Thank you all so much.
Thank you very much, Kimberly. I appreciate that, all of that information that you just provided. The one thing I did want to kind of add to it is two things. One is the hearing versus the listening, because oftentimes people are listening for you to take a breath so they can tell you what you think and or what you should be thinking or what the other side should be doing. And just being aware that if that's occurring, maybe perhaps asking a question related to that. Did you hear perhaps what was being said? This is what I heard, kind of situation. The other piece that I often talk about for us as mediators, for we as mediators, whatever the appropriate grammatical structure is. The key thing is that we need to make sure that our mind is not 5 steps ahead of our mouth. And anyone who's ever had to read a deposition or a trial transcript knows exactly what I'm saying. Your mind was 5 steps ahead of your mouth. You read what you said and you're going, that's not what I meant. But we were already thinking about the next step or the next question or the next piece that we needed to do. And so what I would just like to add is we need to, as mediators, always try to be in the moment and try not to wander. To me, it's almost like meditation, where you're trying to block out other things that might distract you from your relaxation. To me, it's the same thing. Don't let other things, like even your own thoughts, interfere with listening to where they are and following them where they need to go. Because if you're already thinking ahead, then you're no longer in the let's elicit, let's listen, let's hear mode. You are now into the how can I solve this for them mode. And that's one of the hardest shifts, I say, in paradigm, when you're making your paradigm shift away from your general role to your role as a mediator. You need to stop that kind of process. Did anyone have any questions? Should we ask a quick question about how virtual versus in-person is affected? One thing I would say is, picking up on what Kimberly was saying earlier, I would rather do a Zoom mediation where I can see the facial expressions, but might lose some of the body language versus the mask in an in-person setting. There are some things about the virtual that can create issues, but I think it is the next best thing to normal, and I say normal, who knows what normal is, normal in-person interactions. Did anyone else have anything that they wanted to add of our speakers?
Well, Cece, the thing that I think is perhaps most concerning about the remote is where you have parties who are not, who don't have the resources to have good electronics, or living in Wi-Fi deserts or whatever, and they're there, but kind of intermittently and imperfectly. That's a real factor to take into consideration in the difference between in-person and remote.
That's a very good point. John?
Yeah, I just wanted to, I'm going to shift ground for a second. I'm going to ask Angela if she would make the slides that I have. There's 3 of them with different questions. Make them available to all the attendees, because the last slide I couldn't get to show. And then there was one question in the chat that I would just address, and that was, do I get permission from the attorney to speak with the client? Yes. When I speak with the client, it's usually on the day of mediation, and I ask them in the pre-mediation call if I can do this. If they say yes, that's implied consent from the attorney to talk to the client.
Yeah, if I could just add to that, my whole career has been, you never talk to a client of a lawyer without getting the lawyer's okay to do so. And, that's just inbred, and even more so as a judge, you never try to get in between a lawyer and a client. Now there's ways to point out, as it has been explained, about what some of the differences are between the lawyer and the client when you have them both together. But even there, I try not to get the client to feel like their lawyer is not a good lawyer, because I think that's leading nowhere.
I agree. Absolutely agree.
So don't roll your eyes when they say something that isn't correct under the law.
I think the best thing is when a new lawyer has come into the case, and we can all dump on the previous lawyer, So that way we don't have to dump on the current lawyer. We can dump on the previous lawyer, you know. There's no-
Well, when it comes to people's perspective of the process, pleadings is very important in family law. And I often, if the lawyers aren't present, throw them under the bus by saying lawyers have to put all sorts of things in there to make sure it's in there the whole time. But let's talk about how you each feel. So sorry, lawyers, when I throw you under the bus. The other piece that I do think comes through with all of the speakers is making that connection. We need to make a connection with the people in the room so that they know we are hearing them as well as listening to them, and that their perspective is very important. And we'll listen to the attorneys and we'll listen to the other side, but we want to hear from them. And that often is really where you're able to have them really engage in the process. The final piece that I would like to say is every one of us has made mistakes in mediations where we've said something that was taken in a way that we didn't anticipate it would be taken. One of the greatest things we can do is apologize and simply say, I'm really sorry. It didn't come out the way that I meant it to come out. This is the concept I was trying to give to you. You know, the apology coming from us, I think, is very, very powerful when we take it on ourselves. Kind of like when Judge Sweeney was talking about the self-deprecating humor. You know, it is about us being, you know, part of the process, but we're human beings as well. And therefore, you know, we want to make this work. Were there any other comments or questions? I know I also sent Angela the actual page, I think I may have mentioned this before, that John was talking about from the landscape survey that talks about eliciting and the other processes, the ones that work and that participants have said have worked and the others that have not worked. So you'll all be getting that as well.
Thank you, Cece, and thank you to all of our speakers.
Okay. And by the way, the Lady Terps are playing right now on ESPN2, and they're beating Alabama by 40-19.
Yay!
That doesn't mean I was watching it while this was going on.
Okay,
Of course.
All right, go Terps. Yeah.
there you go.
Thanks, everyone.
All right, thank you all, and thank you to Judge Sweeney, John Greer, and Dr. Kimberly Cuthrow for taking the time to do this presentation. Have a great day, everyone.